They have eliminated rural residential and sewered residential as zoning classifications which are capable of hosting an off-site parking lot facility. So again, difference between the town of Dayton's petition and the county and Koeper-Peterson petition is that the town of Dayton's petition says that off-site parking is not a conditional use, in other words, it's prohibited, within the rural residential or sewered residential zone. As it relates to the amendments to allow for the off-site parking as a conditional use in any zone, there are distinctions related to the conditions associated with that allowance or that conditional use between the three petitions. In the Peterson-Koeper amendment, they've added additional qualifications to that aren't in the county petition. The two additional qualifications are, first, that the district must be the same between the two parcels that are to be utilized. In other words, if, for example, a particular parcel is zoned commercial and that commercial establishment wants to utilize another parcel to serve that commercial establishment for parking, that other parcel must also be zoned commercial. In other words, there has to be consistency between the zoning classifications of the two parcels in question. In addition, they've added a distance limitation, and they've said that the parcel that will host the parking lot and serve the other commercial venture must be within 500 feet of the parcel where the commercial venture is located. Those two conditions have again carried through on the Town of Dayton petition. So you have similarity between the Town of Dayton petition and the Peterson-Koeper petition, which is different than the county petition.
I practiced at Quarles & Brady, a prominent Milwaukee law firm. I'm here on behalf of a large group of Waupaca residents and business owners who oppose the zoning office's petition to amend the zoning ordinance with respect to off-site parking. As the committee is aware, there have been countless emails, letters, and phone calls opposing the county's plan to allow residential property to be used for off-site commercial parking. Since I have been given extra time to speak on behalf of this large group, in the interests of time, some others will not. This committee should not take that as any indication that the opposition to this action is not as committed as ever. Why do we oppose the zoning office's petition? It's simple. 1, it's bad policy. 2, it's an extreme proposal. Even the county's own outside counsel, Andy Phillips, has said he is unaware of any other county in Wisconsin that has this provision in their zoning ordinance. 3, it thumbs the nose at all the business owners in Waupaca who have done the right thing by buying enough commercial real estate for their customers and employees to park. Bottom line, commercial parking lots should not be allowed on residential property. Off-site parking is undesirable and not compatible with residential neighborhoods. Everyone recognizes that. Parking lots are an eyesore. They bring light pollution, noise, litter. They increase traffic, cause runoff into wetlands and lakes. They hurt property values and are a magnet for crime. So in counties that do allow off-site parking, there are strict limits as to where and how. The zoning office's petition opens the door wide to off-site parking everywhere. We strenuously object. What do we want? We want the committee to amend the zoning office's petition to adopt the language from either the Town of Dayton's petition or the Peterson-Koeper petition to establish 2 minimum requirements before a conditional use permit may be considered. 1, off-site parking may occur only on property with the same zoning as the property being served. And 2, only within 500 feet of that property. In addition, the Town of Dayton petition expressly prohibits off-site parking in residential districts, which we would support as well. When I mentioned I was researching a zoning issue in Waupaca County, I was often greeted with something to the effect of, "Oh, Waupaca County, anything goes there these days." Or, "Waupaca zoning? That's the Wild West." Not my words, theirs. Is that really the reputation we want? The other day, in a meeting with the towns, Attorney Phillips referred to our petitions as unique and unusual. There is nothing unique and unusual about them. They contain common provisions based on precedent, as you've seen. What is unique and unusual is the county's proposal, and the fact that residents and a township became so frustrated that they filed their own petitions to amend the ordinance. It's a process allowed under Wisconsin law, but usually not a step most towns or county residents have to take. The frustration was caused by the county's tone-deaf process. That process failed to take into account overwhelming public concerns that began pouring in last summer and have continued since, overflowing the Farmington Town Hall when the director called an informational meeting last October. The process has ignored the official actions taken by the two towns most affected by the proposed ordinance, Dayton and Farmington. Both of their plan commissions and town boards support the language of the Peterson-Koeper petition. The county process ignored the public input when, at its March 4th hearing, a revised proposal was to be put forward to address comments received. Yet very little changed. Parking lots are still going to be conditionally allowed on every property without regard to zoning.
Of Dayton has put together a very good petition. I strongly support it. Our petition is very similar to the Koeper's petition. The only thing that we're saying that we want to add is off-site parking not allowed in residential property. That'll leave it there. I also feel that having the addition to the petition that we have regarding notice that Mr. Phillips has gone through, I think is very important. I think any notice of a conditional use permitting process is important for your neighbors to know how you want to change it. I think it's just a common courtesy.
And I just wanted to address a couple issues before Mr. Maiman talks about the particular situation with his property. First of all, I think it's important to bear in mind that we're talking about an amendment that impacts a lot of people, not just the Wheelhouse Restaurant. And I know the focus has been on that, but there are a lot of other properties that could be impacted by this ordinance one way or another. Second thing is, I understand, and excuse me, I represent a number of municipalities, including townships. I understand the importance and necessity of working with townships. However, as I'm sure you know, and Corp Counsel, Mr. Phillips can discuss with you, this particular property is in a shoreland area within 1,000 feet of a lake. And under the statute since 1970, counties were required to zone shoreland areas. The county has exclusive jurisdiction in zoning in shoreland areas. As a matter of fact, the statute provides that unlike other zoning amendments that are in non-shoreland areas, the statute specifically provides that ordinances and amendments in shoreline areas do not require nor shall be subject to disapproval of a town. Now, I'm not suggesting that you ignore what the towns have to say. What I am suggesting to you is that since 1970, the legislature has sought the need to make final decisions on these types of things vested exclusively within the county.
Of the Wheelhouse and Scooper's ice cream parlor. I have owned the Wheelhouse since 1977. This will be my 39th summer in business, and it's been quite a run. Obviously, I'm not a new kid on the block here. I have seen, the Channel Lakes area grow over the years from little cottages into bigger homes and everything else. Population-wise, it has grown. As far as tourism goes, it has grown. We've seen small businesses turn into big ones. I'm sorry, I run mine well and I have expanded it and it does well, and I do that for the public. I don't think anybody here would not try to improve their business and do things better. Mr. Maiman is here. The Harbor Bar, that started out as a small little postage stamp of a bar as well, and he's had to expand. And he has had to expand to be able to take care of the general public and the tourism industry and the people that are coming in. Mr. Maiman has had to be able to get some off-site parking for his business in order to have ample parking for his employees and customers and whatever else. He's running boats, he's got to be able to have bus parking and everything like that. There's other businesses in the area that have purchased properties that are not on premise. They have Chain Lakes Bar and Grill purchased a couple pieces across the street so that they could have a place to park their employees, so that they didn't have to use up their whole parking lot for just their patrons. We got Camp Onaway. Camp Onaway parks all of their cars on a residential piece of property on Otter Lake Road, which is totally fine, I guess. You know, last time I went there, I counted last year, there's like 24 cars, about 6 or 8 boat trailers, and other various things that they use in order to run Camp Onaway. So the staff has to have somewhere to park, and they park there. I have not personally parked any of my employees on the premise at the Wheelhouse for over 10 years. The last 3 years, I parked them across the way from the parking lot in question that we're talking about now on the piece of property that I purchased. I parked them across the way over there, and that is totally on residential property. I never had incident, I never had a complaint or anything of that sort, so there was no reason for me to think that I would have a problem with what I was trying to do. I felt that that was an eyesore, all those cars parked out there in the middle of a field. And like I said, I thought that that was an eyesore. So it was a natural move for me, seeing as how I had rented the piece of property from a gentleman that had just died. And my lease was up. I had a 3-year lease on it. So I had been looking for a while for that piece of property. The fact that it was right across the street, I felt that was good because then the employees would know exactly where it was. The fact that it was wooded was a concern of mine, yes. But I hired a friend, Terry Martin, and a well-known architect and a former resident of the Waupaca area to do a plan that would take all of my concerns into consideration, which were so that I would have some sort of a buffer zone, so that we would research lighting so that we would not flood the skies or do anything of that sort in order to keep our neighbors happy and not flood the skies with light or anything of that sort. This is specifically just a employee parking lot. This is not a public parking lot, so it isn't like cars are coming and going all the time. Or if they park in my lot, you are going to take all of the customers that come to the Wheelhouse now, existing, and they are going to start parking wherever they feel they want to. So they talk about neighbors and they talk about everything and they talk about safety and they talk about privacy and this and that. They obviously don't have any concern about their neighbors that live across the street from me, whom I get along with very well. I mean, I have even opened my parking lot to those folks when they have company. Now, you're gonna take and people are not gonna stop coming to the Wheelhouse. I mean, let's face it, it's been there going on almost 40 years now, and I'm not gonna be there forever. What I'm fighting for is the longevity of the Wheelhouse. I'm fighting for the Wheelhouse existing as we all know it, and Scoopers, and the employees of the Wheelhouse, and for the people that enjoy coming to the Wheelhouse. If I put all of those people into my lot, I lose half my lot. The rest of the people in the general public is gonna go and they're gonna park wherever they want to. They are going to park on the streets. They're going to park, it doesn't matter if it's daylight or if it's nighttime. Is it lit? Maybe not. Could be this, could be that. People walking back and forth that are trying to get an ice cream cone, the little kids, such as that, darting in and out in front of cars, in between cars on a road. Does it take somebody to get hurt? Does it take somebody to get killed before we figure out that, hey, listen, we need to find some parking? I'm not trying to create a problem here. I never was. I'm trying to solve a problem. Now, whether or not I'm doing it correctly or I did it correctly, I'm not sure. I'm not a lawyer. I don't have all the fancy words and I can't state all the fancy things that should be stated at this point in time. I'm a hardworking individual that's worked very hard to build the Wheelhouse and Scoopers into what it is today. I am just fighting for the people, the public, the safety of the public, the safety of my employees, and the future of the Wheelhouse and Scoopers. I'm not going to do this forever. They're the best ones that can do this. Nobody else knows how to run the Wheelhouse. I don't want to sell it to anybody. I'd rather give it to them. Let them continue on. I think a lot of these folks that are here and are sitting down here that might be opposed to the off-site parking are probably good customers of the Wheelhouse.